एहसास न्याय का सबके लिए, आकाश न्याय का सबके लिए, उल्लास न्याय का सबके।
Greetings everyone, I'm Advocate Varun Pandankar. I will be introducing you to a fantastic guest on this series that we call the Judicare series. The speaker is none other than Advocate Parag, who requires no introduction whatsoever. He's been practicing before the Honorable High Court, various courts and forums across Goa. He will be talking about a subject which is commonly referred to as check bouncing, but the act itself is known as the Negotiable Instruments Act. Perhaps every chamber across Goa deals in such cases, but he will specifically be dealing with one topic in this act, that is the dishonor of checks. Thank you so much, sir, for taking time for this series, and over to you, sir.
At the outset, I thank the Goa State Legal Services Authority for inviting me to deliver the talk on dishonor of checks. On account of constraints of time, I shall discuss the topic at hand without any further ado. In the olden times, there used to be exchange of goods and services, which was called the barter system. However, the method and manner of conducting business changed over the succeeding centuries, and more particularly in view of the banking operations, setting up of banks, and in view of negotiable instruments, as we know under the Negotiable Instruments Act 1881, businesses started to be conducted by way of issuance of checks. Negotiable Instruments Act 1881 is a pre-independence act. I shall refer to that as NI Act henceforth. Now, under the NI Act, essentially what is dealt with is a promissory note and a bill of exchange, which could be a demand draft or a banker's draft, and a check, which again is a bill of exchange. The objective of the NI Act is to inculcate faith and efficacy in the banking operations and to lend credence to transactions conducted by checks. The Parliament has played its part in introducing a number of amendments starting from the year 1952 and ending with the year 2018. It has gone all out to ensure that unscrupulous drawers are punished sufficiently and swiftly, and innocent drawers are protected from undue harassment. The Supreme Court itself has expounded the law on Section 138 and has made it friendly for the payee, and we owe a lot to the Honorable Supreme Court for interpreting Section 138 in a broad-based manner. At the heart of today's talk is Section 138 and the interconnected sections. Now, Section 138 is penal in nature, in the sense that if the accused is convicted, he can be punished by way of imprisonment and by imposition of fine. Now, the person who draws a check is called a drawer of the check. The person in whose favor the check is issued is called a payee. Now, when a person issues a check in lieu of the goods or services that may have been supplied to him, or for discharge of any debt or liability, provided that the debt or liability is a legally enforceable debt or liability, and if the check is dishonored on account of funds being insufficient in his account, or on account of the amount of the check exceeding the arrangement made by him with the bank for payment of a particular amount, then he is deemed to have committed the offence under Section 138. However, the offence is not completed and the person, that is the payee, does not get a right to file a complaint unless the three contingencies, which are in the form of a proviso to Section 138, are satisfied. The first contingency is that the payee should deposit the check within its validity period for collection. Now, this validity period has been reduced from 6 months to 3 months by the RBI by issuance of a circular in the year 2011. Secondly, the moment he gets intimation that the check has been dishonored, he has to make a demand by way of a written notice on the drawer within 30 days from the receipt of this intimation that he should pay the payee. Thirdly, if after elapse of 15 days, the drawer does not pay the amount, then a cause of action is furnished to the payee and he has a right to launch prosecution. Now, when we are discussing this section 138, a couple of questions which may come up in the mind of a payee, I will address those questions. Firstly, a payee may want to know whether he can deposit the check only once or multiple number of times. It so happens many times that once the check is dishonored, the drawer may say that please give me some accommodation, I will arrange the funds within 15 days, you may deposit in 15 days. Now, the payee can certainly deposit the check multiple number of times, provided he has not issued the demand notice to the drawer. Once the demand notice is issued to the drawer, the limitation kicks in. So, till the demand notice is issued, you can deposit the check as many number of times as you wish, but within the validity period. Second question that may come up is, does the notice have a particular format? The notice does not have any particular format. All that is required is that it should be in writing and there should be a demand. Thirdly, a question may come up is, what happens if the drawer does not accept the notice? Now, it is always advisable to issue the notice by RPAD, because there is a presumption under section 27 of the General Clauses Act that if a notice is addressed to the correct person at his correct address and after that it is unclaimed, it will be presumed that he has been served. So, that is why it is important that this step is resorted to while issuing written notices. Third question that may arise is, what is the limitation for filing a complaint? The limitation firstly starts once 15 days have elapsed from the date of receipt of notice by the drawer and he fails to pay the amount. From that date, within a month, you are supposed to file the complaint. Now, what happens if the complaint is not filed within 1 month, whether the court has the power to condone the delay or extend the limitation? The court indeed has powers to condone the delay and extend limitation, provided sufficient cause is shown. But this has been brought in only by way of amendment of 2002. Now, another question which is a vexed question is, in which court the proceedings can be filed? Now, this up to the year 2009 was being determined by the law laid down by the Honorable Supreme Court in the case of K. Bhaskaran in the year 1999. The Supreme Court then held that whenever the check is drawn by the person, that place, wherever the payee deposits the check, wherever from he issues the notice, or wherever the check is returned to him by the bank, or wherever the notice is received by the drawer. So, this was being misused in the sense that even if the person was, say, in Delhi, the drawer of the check, and the payee was in Goa, but he would travel to Rajasthan and deposit the check there, then the drawer would have to travel to Rajasthan. In case of multiple checks being issued, the complaints used to be filed in multiple jurisdictions. So, this was creating a little bit of a havoc. Then in Harman Electronics, the Supreme Court said, which is a judgment of the year 2009, that all 5 predicates except the predicate that the place of issuance of notice should not be where the complaint can be filed. So, it restricted it to 4 cases. Then came the decision of Dashrath Roop Singh Rathod in the year 2014, and the Honorable Supreme Court restricted the place of filing complaint to a place where the check got dishonored, that is the bank in which the drawer maintained an account. Now, this was obviously inconvenient to an honest payee because he would have to travel all the way to the place where the drawer maintained his bank account. Now, take a case where a person issued a check from Delhi, A issued a check from Delhi to a person B in Goa. Now, since the check has got dishonored, B would have to travel to Delhi where A maintained his bank account and file the complaint. But this did not last for long, and the Parliament stepped in by way of 2015 amendment and introduced section 142 subsection 2, whereby now the law provides that if it is a check sent for collection through account, then the payee can file the complaint wherever his branch of his bank has an office. If it is not presented for collection through an account, then wherever the drawer maintains an account. So the air on jurisdiction or territorial jurisdiction has been substantially cleared by the 2015 amendment. Now another aspect that may crop up is what happens if the drawer, after issuance of the check, issues a stop payment instruction to the bank or closes his account, whether this would invite the criminal liability under section 138. The answer is yes. Previously, if you had noted, section 138 deals with only two contingencies. The first is the funds should be insufficient. The second is that the amount on the check exceeds the arrangement made by the drawer with the bank. Now, if one was to read this as it is, then obviously any other reason because of which the check gets dishonored would not be covered by this. Many high courts took this view because they said that this is a criminal liability and it has to be strictly construed. So construed, any other contingency would not make the drawer liable for offence under section 138. However, the Supreme Court stepped in, and in judgments of Modi Cements Limited, MMTC Limited, the Honorable Supreme Court clearly held that stop instructions to the bank or closure of account would invite the wrath of section 138. The Supreme Court applied the Hayden's rule or the mischief rule as against the literal interpretation. The Supreme Court said that we have to suppress the mischief and advance the objective of the act. Doing so, the Honorable Supreme Court expanded the scope of section 138, and even these categories would make a drawer liable for punishment and offence under section 138. Now I shall briefly deal with the amendments of 2002 and 2018. Now in 2002, the punishment that can be imposed by way of imprisonment has been increased to 2 years. So the deterrent effect of section 138 has been enhanced. Apart from this, sections 143 to section 147 have been introduced by the 2002 amendment. Now in terms of section 143(3), the trial court should make every endeavor to dispose of the trial within 6 months from the date of filing of the complaint. So the procedure is expedited. In terms of section 144, since a lot of time was being wasted in serving the accused, it is permissible now to serve the accused by speed post. Now section 145 introduces evidence being given on affidavit by the complainant. Thereby it negates the need to go to the court and step into the box and give evidence under section 200 of the CRPC 1973. Section 146 provides that once the memo of the bank is produced, there would be a presumption that there has been a dishonor of check. Now section 147 specifically provides for compounding. Now the amendments of 2018 are interesting and important from the point of view of the payee, because firstly it introduces section 143A, which authorizes the court, once the trial commences, that is when the accused pleads not guilty and the trial commences, to order that he should pay 20% of the amount of the check as interim compensation to the complainant. But this section has been held to be prospective. Then section 148 provides that once the accused is convicted and he goes in appeal, the appellate court can order that he should pay a minimum of 20% of the fine or compensation awarded by the trial court during the pendency of the appeal, and this amount is in addition to section 143A. So the payee is substantially compensated during the pendency of the trial itself. Apart from this, the Honorable Supreme Court in the case of D. Prabhu has clearly held that compounding should be resorted to by the accused at the earliest. The Supreme Court has given guidelines that if it is done at the first hearing or the second hearing, it should be done without imposing any cost. But if he goes subsequent to the first or the second hearing for compounding, then 10% of the amount of the cheque would have to be deposited as cost. 15% of the amount if this compounding is done before the Sessions Court or the High Court, and 20% in the event the case is compounded in the Supreme Court. And the courts have been following this, and in the summonses which are issued, the courts make it clear that if the compounding is done at the earliest, no cost would be imposed, and there is gradation of cost. The Supreme Court is now seized of a matter which is suo motu writ petition 2 of 2020, where the Supreme Court is finding ways and means of expediting trial in 138 cases. The Supreme Court has stated that the High Court should issue practice instructions to the trial courts to ensure that if they want to convert the case from a summary trial to a summons case, then reasons should be recorded. So the Supreme Court is exploring ways and means in which the proceedings can be further expedited. So all in all, as of now, as the law stands, conducting business by way of checks is safe, and the accused would be brought to the book swiftly and would be punished sufficiently. Enough compensation would be paid to the payee, as the court has powers not only to sentence the accused to 2 years imprisonment, but it can impose a fine twice the amount of the cheque, and either or both can be done. So, Negotiable Instruments Act 1881, as it stands amended, is an effective legislation, and if the mandate of section 143(3) is followed, or if dedicated courts are formed, then it would be all the more satisfactory, and it would definitely inculcate faith in transactions conducted by way of checks. Thank you very much.
That was an illuminating speech. We express our deep gratitude to you, sir, for enlightening and educating us on today's topic. Thank you, sir, once again, and I request you all to like, share and subscribe to this channel.
राष्ट्रीय न्यायिक सेवा प्राधिकरण
न्यायालयातल्या कारवाई खातीर बरो वकील मेळून दिता.
वेळार योग्य कायदा खालची मदत आणि सल्लो दिता.
लोक अदालत द्वारा चड काळच्या केसीक बेगीन सोपयता.
आणि ते बी सामके मोफत.
राष्ट्रीय न्यायिक सेवा प्राधिकरण, बेस बरो न्याय, बेस बरो समाज.
अधिक माहिती खातीर लागच्या न्यायालयातल्या न्यायिक सेवा प्राधिकरण कार्यालया लागीं संपर्क करा
वा टोल फ्री नंबर 151000 चेर फोन करा.